Mr. Baylor, good morning.
Good morning. May it please the court. Jeffrey Baylor for Jesus Silva-Santiago. In this case, Mr. Santiago is convicted of first-degree murder under a theory of extreme atrocity or cruelty. First off, we contend that the trial court erred in denying Mr. Silva's motion to suppress the identification as unnecessarily suggestive. When reviewing this type of claim, court looks to the totality of circumstances regarding the identification. It's not a question of whether the witness was mistaken, but if any possible mistake would be the product of improper suggestion.
I just want to get the photo in front of me. Your argument is that is it pretty much focused on this haircut? Is that what you're saying? Or are there other things about
many
it?
Many factors,
Okay.
7 in total, but the haircut is one.
Because when I looked at that, it seems to me that with respect to the haircut, the person that's on the, in 8 and 6, depending on what page you're looking at, isn't so dissimilar, is it? I mean, I guess there's a bunch of haircuts that I would have thought look fairly close.
I'm not sure which, are you talking about 8 in the top? Or
No,
8 in
I'm
the
sorry,
bottom?
8 on the bottom, and who I think is also,
Well, 8 in the bottom has a much more, well, if we want to get specific about the haircuts, 8 in the bottom has a much more circular kind of haircut
okay.
than 2, which is the one identified as Mr. Silver, which sort of goes down in the middle and then comes down sharply. And I know that in many cases, an array of this type would be fine, but in this case, the witnesses focused in on the haircut of the shooter. They told police right after the incident that the shooter had a short fade type haircut. And then, I mean, there was never a definition or anything like that given as to what a short fade haircut was at trial. But then after, at the time of the photo identification, 2 of the witnesses focused in on the hair. Mr. Bruno said, that's him, he has the same hair. And Mr. Johnson said, that's him, I recognize his hair.
Would you say to not be suggestive, you would have had to have an array that I mean, I'm not trying to be flip, but that would have hats on or something like that?
No, well, I mean, when they say, when they're focusing on this particular characteristic, a haircut, they should have others who have the same type of haircut. You know, if they said, for example, in, I believe it's the Reynolds case I cited in my brief, where the witnesses focused in on glasses, and there was only one person in the array wearing glasses.
May I ask you, now, as I understand it, what the police did was they locked all the patrons of Mike's Lounge into the lounge, and then they took videotapes as they left,
Right.
and then they used the videotapes to make photographs.
I don't believe.
Is that how they did it?
No, I don't believe that they.
Well, after they did the videotapes, what happened?
I believe they used the videotapes to see who was wearing similar clothing, and then they got a picture. I don't. These individuals in the array are not all from the videotape. Just Mr. Silva was the only one present. These other so-called fillers were not patrons of the bar. I mean, maybe that would have made made the identification much more credible, but that's not what they did. In a second factor we contend made it suggestive is that 2 of the witnesses, Mr. Bruno and Mr. Johnson, were brought back into the bar right after the incident. Police locked the doors of the bar, believing that maybe the shooter went back in and he was still there. They took these 2 witnesses in who were friends of the decedent, and they both one testified he looked all around, and the other one testified he looked at every person, and neither one of them pointed out Mr. Silva, who was present at the time.
The Commonwealth says, and that each of those witnesses was in the bar for this purpose for seconds. Is that correct?
That's what the police testified to, but the witnesses themselves, one said that he looked all around, and the other one said he looked at every person. So the police said they were upset and they were in there for a short time, and maybe they were, but the witnesses themselves testified that they looked around and they didn't see.
I take it the police took them back into the locked bar in order to see if they could identify the suspect.
Right,
A suspect.
right.
So I presume the police gave them enough time to look around and to say, no, I've looked around and the shooter is not here.
Well,
I mean, however long you describe it, as seconds or whatever it is, that's why they came back in, right?
that's why they came back in. But I think what the Commonwealth alleges is that they were so upset they had to leave.
That's a different thing. But I mean, it wasn't as if they said, look, I left my pocketbook or I left something and I've just got to go in and out.
Right,
They came
right,
back to look
right.
at the people in the bar to see if they could identify a suspect.
Right. And both witnesses said they did look around, regardless of what the police said, how quickly or how upset they were. They both said they looked around and they didn't find the shooter. So again, we contend that this added to the suggestion because it's quite possible that these witnesses, when they saw the array, they said, oh, there's that guy in the bar. He's the guy who must have done it. That's what the police think, so that's who I'll identify.
Well, this isn't exactly that case. You've got, I guess the estimate is 50 people in a bar. It's not like the police took them in and, there was one guy in there.
No, but you've only got
Took 'em
one
out.
photograph, right? Your point is that there were not pictures of other people in the bar in the photo array.
Right.
Well, I guess my point is this. It doesn't seem to me that there's anything suggestive, unnecessarily suggestive, about the police bringing these folks into a crowded bar to see if you see the guy. Nothing suggestive about that. So your point is the fact that there was only one photo from a person in the bar there
Well, that's
was the problem?
That's one aspect of it. And I'm not saying that it was suggestive to bring them in the bar. What I'm saying is suggestive is after they've been in the bar and they look all over and they see my client, and then later on he's presented in.
What was the time span between that day, I mean, the bar, and when they actually did the array?
It's in my briefing. I don't remember.
Is it
I don't wanna
weeks or-
I think it was a short time.
Yeah, I think it's 9 days.
9 days? And you had an expert, right?
Yes.
Did the expert offer any opinion testimony about whether however long this trip into the bar would have had an impact on them?
I don't think that came up. She testified more generally about some of the other aspects of the identification that I put in my brief. For example, about it being all in one sheet of paper rather than showing one photo after the other, and that it was the investigators knew who the suspect was, which are other things that we contend adds to this suggestion. In this case, it's called relative judgment, that when a witness is looking at a bunch of photographs, if they're all on one sheet right in front of the witness, they're likely to use their relative judgment and select the person that looks most similar or most familiar to them. And also in this case, the troopers who administered the identification knew who the suspect was. And again, we contend this allows them to give cues, maybe not even knowingly, as to which suspect was submitted.
Well, was there any testimony that suggested that happened?
Well, beyond the expert's testimony that this study show that this is a possibility, I mean, there's no way to show, no, there was nothing to show that it was specifically, they said, like, that's the guy, or, pointed to him. But even unknowingly, maybe police officers' eyebrows are raised, or they're staring at this one photo.
Let me ask you this. Going back to your first point about your position is that the defendant was the only one with the particular haircut style.
Right.
Looking at the pictures, would you agree that they all have short hair?
I wouldn't agree with that. I mean, if you look at his haircut, it is very, very short. And for, let's say in the bottom picture, number 3, right next to him, his is much longer.
Well, I'm looking at number 1
Okay.
on the bottom. Is
Yeah.
that short?
I would say that that's just as short, but again,
Number
that-
6 short? Number
may-
7?
Maybe. I'd
So-
say 6 and 7 are longer than my clients.
No, how about number 4?
Number 4, maybe not. I would say not as short. But even these pictures where there is someone who has this short hair, it's the hairline that's shaped differently too.
And your position is that everyone in the array should have exactly the same?
Well, it doesn't even have to be everyone, but at least there could have been several, or more than one. Especially where here they're focused in on the haircut as being an identifying factor. And then we see that, when they did do the identification, they focused on the hair. So we know that it must have been distinctive, regardless of what we think or what we see. We know that the witnesses thought that it was distinctive.
Can I ask you this, Chris, just sort of how this played out some of these things played out at trial? Was it the defense that Mr. Santiago was not at the bar that night, or rather was it sort of conceded that he was at the bar, but he wasn't the shooter?
Yes. In fact, the defense presented a witness who said at the time of the shooting, this witness saw Mr. Silva in the bar at the time.
Was it disputed that he was wearing, when he was in the bar that evening, that he was wearing the clothes that looked like the clothes described by the eyewitnesses?
Well, the eyewitnesses described a red shirt, and the evidence showed that he was wearing a red shirt with gray sleeves. And when they searched his house, that's what they seized.
But they also seized red and white sneakers, which the witnesses also said, didn't they?
Right, yes. But I don't think that they, either one of them is very uncommon thing.
But I guess
right?
is it disputed that was it disputed at trial that you said, no, we're not disputed that he was at the bar that night?
Right.
And was it also not disputed that he was wearing clothes similar to those described that night?
Right.
Okay.
Was it clear at trial why his photograph was the one in the photo spread before the IDs were done?
I'm not sure if I follow your
Was
question.
it clear why they were showing a photo spread which includes Silva as opposed to somebody else before they had any IDs of him as the shooter?
You mean clear to the police?
Was it clear at trial? Was there any evidence as to what caused them to make a photo spread which had Silva in it?
That his clothes matched the description given by the witnesses.
So it was based solely on the clothes.
Right.
And was the videotape that was taken of the people leaving a part of the evidence as well?
I don't believe it was, but there was there's some testimony that the videotape might have been shown to these witnesses prior to their identification too, but it was not really flushed out during the case.
But the videotape of people actually leaving the bar, including Silva, was not shown to indicate what clothing he was wearing.
I don't believe it was.
Have you looked at that videotape?
Yes.
Can you see the clothes that, I haven't looked at it. Can you
I'm
see
trying
what
to-
people are wearing?
I'm trying to remember, but yes, I think you can. And also with this idea, there was no other instructions given to the witnesses like the suspect may or may not be there, or our investigation will continue after this. So basically, the witnesses are confronted with this picture that looks similar, has a similar haircut to the person they recall, and they think that, the police, he was in the bar, and then this must be the person the police think who it is.
What did the police say? Did they say, do you recognize anyone, or how was it framed?
I believe it's quoted in my brief, but they said something to the fact, look at these photos and see if the shooter is in there.
Well, that's pretty open-ended, isn't it?
It is, but again, it's not, it doesn't, when there's this suggestive other aspects, I mean, there's some things that maybe could have saved this, like they said, if they said, look at these pictures, maybe the suspect's in here, or maybe not, or our investigation is going to continue. They could have done something to try and negate this judgment, relative judgment, like them being on the whole sheet, or bringing them in and seeing the witness before, but they didn't do anything. So again, it might not be the major factors, but all these put together contribute to being it unduly suggestive.
In support of what you've just said, are you looking to the fact that one or both of them said something to the effect of number 7 or number 2, whatever, looks the most like him? I mean, in other words, is your point that suggests they thought their task here was to find someone in this array of 8 that came the closest to the person?
I mean,
or is that...
That's a good point, and I think that's true. I think Mr. Bruno said that's him, definitely him. But the other 2 witnesses said that looks like him. So again, that's another thing to say that it was overly suggestive.
Actually, Bruno, on page 39, the police officer said that Bruno had said that's him. But when Bruno himself testified at trial, Bruno said, I said I recognized the shooter, but I told them I had a glance. I didn't really see his face, but I had got a glance at the man. And I had told them that number 7 looked a lot like the shooter.
Right. Yeah, I think at the suppression hearing you said it one way, and then at trial you said it the other way.
You've got, okay.
So do you think that these additions to the process of doing a photo ID, you're saying, or are you saying that we should be imposing them sort of as a rule in this
No,
case,
I'm not
in
saying
order to
that at
have a
all. I'm just-
non-suggestive ID, you've got to have, double blind, et cetera, et cetera, et cetera?
No, I'm not saying that at all. I'm just saying that each circumstance has to be looked at the way it is now, and they all contribute. And certainly, I mean, studies show that a double blind is the best way to go, and that a sequential administration is the best way to go. And so I'm not saying that it has to be mandated, but I'm saying that those are factors that this court should consider when looking at the suggestiveness of the identification.
You're almost out of time.
Yes.
And we haven't talked about the other issues.
Yes. And the second issue is that trial counsel was precluded from questioning the main police witness, Trooper Lilly, about other evidence she received that someone else committed the crime.
Well, how does that get in? Or putting it another way, if it does come in, couldn't that happen in every criminal trial, that a defense attorney says, I heard from my people that somebody else did it. Now police go and investigate that, and then during the trial ask the police, well, why didn't you follow up on that lead that I gave you?
Well, I mean, in this case, it's more than just I heard. It's trial counsel wanted to put in a witness who was going to say that he told police, and this was what the word was, and this witness happened to be in the bar.
That was what the word was.
Right.
That's hearsay, isn't it?
It's hearsay if it was offered for the truth to show that that person did it. But under Finney and Bowden and Reynolds, it's not hearsay when it's offered to show lack of police investigation.
But I mean, don't you think, though, that if a witness says, or, talks to the police and says, it's out there in the community, I forget the name, Juanito?
Juanito, yes.
Juanito. It's people in the community are saying Juanito did it, and by the way, he's committed some other murders, too. I mean, that seems to me, you could argue, is at such a level of generality and speculation that, not that it's hearsay, but if you're saying that the police have to chase down things at that level,
Well,
is that
not
what you're
even-
saying?
I'm not saying that they have to chase down that level, but at least they could explain themselves. I mean, this witness could have said, well, that was totally unbelievable.
Oh, I
and
see what
she
you're
could have
saying.
made an answer.
So
you know.
your point is, at least trial counsel should have been able to ask Trooper Lilly that question.
Right, exactly.
Thank you, Mr. Baylor.
Thank you.
Mr. Bradley? Good morning.
Good morning. May it please the court, John Bradley for the Commonwealth. I also represented the Commonwealth during the trial of this case. With respect to the identification issue, and more specifically the photo array, obviously the array or the arrays are in the defendant's appendix. The court has seen them already, and I would simply suggest that as photo arrays go, this one was very good.
Mr. Bradley, were the witnesses shown the actual, shown the actual, were they shown these sheets, or were they shown something? Is this a copy of a copy
Yes.
of a copy?
It's a copy of a, I guess, a color sheet that's...
They are Polaroid photographs or pictures that have been, photographs, quote, the original,
No, they were, I'm trying to think of the best way to explain it. They were computer-generated
okay,
pictures.
they're in a computer. It's-
Right,
But they were
right.
color.
Yes, they were in color. That's the only difference, Your Honor, as to what you...
And is the actual, and I'm assuming it came into evidence?
Right,
So
So it's part of the record?
that's correct.
If you don't know the answer to this is fine, Mr. Bradley, but many police departments, now that these things are all computer generated, it's very simple to have sequential photographs. Is there some reason why this police department doesn't do sequential photographs?
I don't know of any department in our county, Your Honor, that does it sequentially.
Oh, they are in other counties.
I know they do it sequentially in other counties, and I go on at some length in my brief to talk about the Illinois study and why the sequential way of doing it may well not be the best way to do it.
I know, and I'm sure you've read Mr. Baylor's reply brief.
I have, but, you know, again, the Illinois study to date, at least to my knowledge, is the only field study, the only real-life study that was done on this issue. And I hope that it was an eye-opener, because what we had previously, we had some a lot of momentum that was generated behind this idea that sequential was the gold standard, the best way to do it, that was based, from what I saw, simply on law review articles, Professor Wells's articles and studies, and some clinical experiments that were done. Here, in the Illinois study, you have real cases, real witnesses, and real victims and defendants. And lo and behold, the results of that study were that the sequential method turned up less positive identifications. I think it was 45% as opposed to 55% with simultaneous. More false positives. Over 9% of the IDs using the sequential method were false positives, where I think 2.8% or 2.9% were false positives using simultaneous. And far less identifications in general. So taking that study at face value, it appears that the simultaneous way of doing it is better anyway. The way we've been doing it all along, or at least most departments have been doing it all along, appears to be the better way of doing it based on this.
What do you say about your brother's argument that it would have been a better array if each person had the same kind of hairstyle?
Well, you know, Your Honor, I mean, if we get to that point where the hairstyles have to be identical or virtually identical, I think we've gone way too far. I mean, I look at that array, I think any reasonable person looks at that array and says, you know, these guys all look reasonably alike. They all have short hair, as was discussed earlier. They all have some facial hair. They all have a somewhat similar mustache. They appear to be of the same ethnic background. I mean, what more do we need? I mean, otherwise you're getting to the point where you have to put 8 lookalikes in a photo array.
Mr. Bradley, were the what race or ethnic origin were the witnesses?
The witnesses, Your Honor, the 3 eyewitnesses were African American.
And 2 of those did the photo ID?
All 3 of them did.
All 3 of them did the photo
All 3 of them did. And, you know, one thing to the credit of the police here, they made an effort to make this, I think, as fair as they could. After they showed the array on, I think it was July 7th, to Bruno and Johnson, they switched the place of the defendant's picture around from number 7 to number 2 in the array before it was presented to Jenkins over at Franklin Park, just to make sure that there wasn't any collusion, that the witnesses didn't have a chance to say, hey, by the way, we picked out number 7, should the police show you the same array, just to make sure we're all on the same page here. So I would suggest that they went the extra mile here to make sure this procedure or these procedures were fair and that they were designed to obtain an accurate identification.
What was the other evidence in this case, other than the eyewitness, the testimony of the eyewitnesses? Other evidence putting the defendant, implicating the defendant in this crime?
Well, there was no question he was there that night, Your Honor. He was at the bar with a group of friends. He was among those inside the bar when Bruno and Johnson were brought in an attempt to make an identification. He was videotaped.
So there was police testimony on that subject. Was there testimony from other bar patrons? Yeah, this guy was there.
Yes, yes. Okay. In fact, one of the women who was with the defendant that night, Tahani Pichardo, testified as to his whereabouts at different times.
And his clothing? And
his clothing, right. The sneakers and the shirt that were seized.
There was a witness, I think, who or your brother said there was a witness who testified that he was in the bar at the time of the shooting.
That's right.
But there was but am I right that there were one or maybe 2 witnesses who said they saw him at the bar, but they didn't see him at the time of the shooting in the bar?
Yes. Tahani Pichardo had him outside at the time of the shooting, as I recall. And one thing I want to point out, the witness, I think his name was Mr. Perez, who testified that the defendant was in the bar at the time, was all over the board. And I think that's an accurate representation of his testimony. He had testified at grand jury that he did not see the defendant in the bar at the time of the shooting. Defendant has raised a number of issues with respect to the identification procedure. He's asked that, I guess not that the court impose requirements on the police to say certain things at the time of an identification attempt, but that they should have been said in this case. And I would simply respond to that by saying, this is really a simple thing here, this presentation of a photo array. You put the array in front of the witness and say, do you see anybody that you recognize? And I don't think we need to go beyond that in any case. I don't think.
Do you see anybody you recognize?
Do you see the shooter?
Yeah, okay.
You know, and it's been phrased different ways. You know, I know some officers will say, do you see anybody that looks familiar? Do you see anybody you recognize? Do you see the person that shot your friend? I don't think the words that are spoken are all that important. I think as long as nothing suggestive is said or done, the array is placed in front of the witness, that's all we need to do.
Could I ask you to just talk a little bit more about the clothing? My memory was that when the witnesses went into the lounge after the shooting, they didn't see anyone in the clothing that they remembered the shooter wore. Am I right about that?
No, Your Honor. They don't get that
So
specific.
they said they saw somebody in a red shirt and red sneakers. He was the shooter.
They give a description to the
Yeah.
police, but they don't talk about seeing people wearing.
But then when they went back into the bar, did they see anyone who matched that description with the clothing?
They don't get that specific.
Okay.
They,
Nobody asked them that. Is that?
No, that's correct. You know, you read the testimony of Detective Williams, and they were in there for less than 10 seconds. They were yelling and screaming and distraught and upset, and, you know.
And then later on, this clothing that matched the description was found in the defendant's apartment.
That's correct, when the search warrant was executed.
I know what you say about Detective Williams describing them as yelling and screaming, and my friend has just been shot. But they also testified, didn't they?
They did.
And did they say I was yelling and screaming and I was distraught, or did they say I looked around and I didn't see anybody that I recognized?
It's more that they looked around and they didn't see anybody. Obviously, the jury could weigh the.
Oh, sure, but I mean, so they didn't testify to being so upset that they couldn't focus on anybody, or did they?
Not to that degree, Your Honor. No, they didn't.
And going back to the question asked earlier as to what the evidence essentially was, I gather that the evidence, in short, was he was at the bar at or around the time of the shooting. You had the 3 eyewitnesses who gave who chose him to some degree from the photo spreads, and you found the red shirt and the red and white sneakers. Is that basically it?
Yes, that's it.
You asked us to reverse Reynolds.
Yes.
Do you lose unless we do?
No, is the short answer. And I do go on to make the argument that, you know, in this case you have one identification on top of another identification on top of another. So you have 3 separate witnesses identifying this defendant, then you have the, you know, the sneakers and the shirt. But I guess what I'm asking is to limit Reynolds more than reversing it. I think the proverbial barn door was open far too wide in the Reynolds case based on the particular facts of that case. In that case, as I recall, there was a defense theory that a couple of Whitey's henchmen might have been the murderers as opposed to the defendant. The defendant, or the victim, and the defendant happened to be in the same bar with these 2 associates of Whitey Bulger that night. So there was some actual substance behind the defense in that case. Here you have some flimsy, unfounded rumor that's circulating in the street that this guy, Juanito Mercado, might have killed this victim and some other guys as well, and that was as far as it went. The offer of proof was painfully weak, and you know, it's obvious hearsay, and the response to that is, well, I'm not offering it for its truth, I'm offering it to impeach the police investigation under Bowden. Well, there's a First Circuit case cited in my brief that has a very good discussion of this issue, how the two theories are really conflated, I would suggest, the impeachment of the police investigation and the third-party culprit. Because no matter what purpose it's offered, the jury still hears this evidence that, well, there was this third guy who may or may not have been a suspect. And my simple point is there has to be some limitations. There has to be some quality control over this type of evidence. And, you know, here the showing was just far, far too weak. It was a simple rumor that was circulating in the community on the streets, and the judge was well within her discretion in foreclosing that line of inquiry.
But it was a rumor that was communicated to the investigating officers.
Yes.
Okay. So did the judge essentially conclude this isn't the kind of thing that police would follow up on anyway?
I don't know if she said it in those terms, Your Honor. As I recall, she basically said that, well, this is just a rumor. That's all you have here.
Well, I'm wondering, is it the implication that the police wouldn't have followed up on it? Let's assume for a moment the police didn't have somebody that they thought they could arrest for this, and that was the only thing they had. I assume they would have followed up on that.
Probably.
Maybe.
If you have nothing, I suppose you're willing to pursue just about anything. But, and, you know, I know under Reynolds, Trooper Lilly could have explained herself. She would have been permitted to explain herself on redirect. But my point is, why do we need to go down that road? Why do we need to create a mini trial on this issue?
So you're saying it's got to be a lot more, there's got to be something more to it before you even permit the question to be asked.
Exactly. Exactly.
Mr. Bradley, you make a fair point. How would you describe the limiting, if we were to limit Reynolds, and bear in mind that not in your case, but for all the other cases that you're going to be trying, do you have some suggestion?
I do, Your Honor, and I actually thought about this a little bit while I was sitting waiting for the other arguments. I think there has to be some admissible evidence that there was a legitimate lead to be followed.
Admissible evidence in what sense?
Something to put this third party in a position where he could have been the culprit. In Reynolds, for example, you had the third parties in the same bar as the defendant in the victim.
So in this case, what would be an example of some admissible evidence that might be?
If, for example, Your Honor, if this guy, Juanito Mercado, was at Mike's Lounge that day and had exchanged some unpleasantries with the victim and his friends, I think then it's fair game.
Or even if he'd been at Mike's Lounge. I mean, that might have done it, but we don't know where he was, right?
We don't know where he was.
The witness, Acevedo, or whoever was... Acevedo, didn't indicate anything other than that's what they're saying in the community.
That's right. That's
Or
right.
I take it you might have one or two, often one, saying it's not this person in the photo array, it's that person in the photo array.
Sure. I
Right.
think that would be, with some background information, you know, as to that person was also, this guy was also there that
Now,
night.
if that person happens to be a member of the police department who happened to volunteer to have his face picture put in the photo array, because, as you know, the photos come from all over the place.
Right.
You know, you can say, no.
But the tip or the information itself, I'm trying to think of the following. Defense counsel hears this, speaks to Mr. Acevedo, sends an investigator out, finds out this person that, say, Acevedo is saying, the community says did this, finds some witnesses placing that person at the bar that night. So you've got proximity. In other words, the information is this identified other person in the bar that night did this. So the defense counsel knows that because they've conducted an investigation. So they would have to give that to the police. The police would then have to decline to sort of pursue it, and then the question would be, you didn't pursue this other lead as, what, evidence of failure to conduct a complete investigation? Is that how it would work?
I think that's a reasonable interpretation, Your Honor. Maybe something generally similar to a statement against penal interest. There has to be something
in the tip. I mean, what's awkward here is the timing, because what you're really, the point you're trying to make is at the time that this matter was under investigation, the police made determinations not to pursue certain leads and to focus on the defendant, and therefore missed, critical evidence.
Well, I thought the author of proof included, or maybe she actually, that the trooper said that she might possibly have spoken to Mr. Acevedo. I mean, so
right.
Something, at least on this record, it appears something was brought to Trooper Lilly's attention. She didn't, but your point is, she didn't need to pursue it, and it was taking us down a very speculative and dangerous route if you get all that into evidence.
Right. I mean, she might have sized Acevedo up to be a complete nut who had nothing legitimate to say.
Justice Botsford has hit on the point that I'm awkwardly trying to get at. Let's assume the information that Mr. Acevedo gave was that rumor on the street is that it's this person, and, oh, by the way, I was in that bar that night, and this person was in that bar at the time, just before the shooting. Would that be enough of sort of, there's real information about real presence in time? Would that be enough to permit the the defense counsel to ask some reasons why that wasn't pursued?
I don't think so, Your Honor. I mean, I think just putting someone in the same bar as the victim without some animosity or some other reason to believe he might have taken the drastic step of killing the victim, I think you have to have something more than mere presence.
Okay.
There's one final issue I would waive argument on unless the court has any questions on the judge's.
I assume you mean you're going to rely on your brief, not you're going to waive argument, no?
I'm sorry. Yes,
He would
thank you.
have argued. Thank you, Mr. Gladney.
All rise.